Good evening, everyone. My name is James Allen. I do thank the Chamber of Commerce for inviting us out on this evening. And I'm born and raised here in Raeford. Been here most of my life. I was in Durham for about 8 years, but I'm happy to be back home. I moved back here in 2014 because I wanted to come back home because I love Hoke County. And like I said, my father, he always taught me that you should always do the best you can to try to support your community. And so that's one of the reasons I came back. And so like I said, I'm happy to be here. I'm happy to look out in the crowd and see some of my former classmates, some of my former teachers, and a lot of my friends and whatnot. And so again, my name is James Allen, and I'm a candidate for district attorney here in Hoke in Scotland County. And again, I'm just happy to be here because it really does my heart good to see our community come out on important events like this so we can be well informed and make well informed decisions. And even though it's a little bit premature, hopefully whenever you go out, you'll consider me whenever you decide to vote for our district attorney. Early voting March 3rd, final day to vote March 15th. Thank you, and again, it's a pleasure to be here.
Good evening. I'm Christy Newton. I am your district attorney. I have served as your district attorney since May of 2000 when I was elected. I took office January 1st of 2001. I have been re-elected in 2004, 2008, and 2012. I'm now up for election this year in 2016. The election is on March 15th. Early voting is March 3rd through March 12th. I would ask for your vote and your support. Hoke and Scotland counties have been very good to me, and I'm very appreciative. It has been my great honor and privilege to serve as your district attorney. I consider my position as district attorney to be a calling. I knew when I went to law school that I wanted to be a prosecutor. I knew that I wanted to do it in my home community. I came back here when I was in law school, and I begged Jean Powell for an opportunity to work in her office. And she said, I don't have any money to pay you. And I said, I don't care. And I came to work for those 2 summers between my first and second years of law school and my second and third years of law school. And I came to work every day for free. And I worked for Jean in her office. And after I graduated from law school in 1995, I came back and begged Jean for a job as an assistant DA. And she didn't have one, but she let me come to work as a temp with no benefits. And I did that for about 3 months until Jean got an opening. And I started my employment in the district attorney's office here in December of 1995, and I have been here ever since. And I have loved it and appreciated it and believed in it. I have a vast amount of experience and training that I believe is relevant to the position because it is not a job that you can do if you don't know how to do it. I would appreciate your vote. Thank you.
Thank you, Ms. Newton.
For our first question, in your opinion, what are the duties and role of a district attorney? What are the duties and role of a district attorney?
Ms. Newton, you do have right of first response.
The job of the district attorney is actually defined in the North Carolina General Statutes. Our job is to prosecute all criminal cases that occur in our jurisdiction. For this position, the jurisdiction is Hoke and Scotland counties. So by law, we are responsible for prosecuting cases, crimes. If you're under 16, that's a juvenile offense. If you're above 16, you're charged as an adult in North Carolina. And so we go to court and we try all the criminal cases. We do everything from speeding tickets to capital murder. But the job of the district attorney is more than just what's in that general statute, because you're a public servant. And so on a daily basis, people come to me. They are crime victims. They are citizens that have questions. They're people who need directions. They're people who need help maneuvering the court system. And we have an obligation to be a public servant and to assist people. I believe we have an obligation to use good judgment. And I think that, well, I mean, we're both lawyers. Everybody who goes up in that courtroom and appears in court is a lawyer. We've all been to law school. We've all passed the bar. But being the district attorney is much more than that. You have to have good judgment and you have to have experience. I've had the opportunity to train under a lot of people who have a lot of experience. I trained initially under a United States attorney. I've trained under Jean Powell, who was prosecutor for 24 years. I trained under Mike Schmidt, who was prosecutor for more than 20 years, Rick Jackson, Regina Joe. The first person I appeared in court with was Regina Joe. She's the one who trained me. how to do court. I've had the opportunity to travel all over the state of North Carolina, outside the state of North Carolina, to train with other prosecutors, with experienced trial lawyers, and I will tell you that you have to know how to exercise the discretion that you're given, when to show mercy, and when it's not appropriate to show mercy. You have to know how to be tough and fair. You have to know when you should help someone and who you should help. You have to be able to stand in front of a jury and talk to them and convince them of the truth, because that's what we do as prosecutors. We don't have a side in the courtroom other than the truth. Thank you.
Thank you, Ms. Newton. Mr. Allen?
Good afternoon. Again, I think the role of a district attorney, you are responsible for prosecuting cases, but one of the roles that I really like about being an attorney is that you're also an advocate. And because this is the district attorney, that means you're an advocate not only for the people who are victims, but also for the district that you serve. And if I'm an advocate for the district that I serve, that means whenever I hear my district crying out, I should advocate for some of the things that we need. So I think the role of a district attorney, yes, prosecution is important, but it's also important to be an advocate for everybody in your within your district and the people you have been elected to serve. And so whenever we have situations going on, like our juveniles, we have a lot of juvenile delinquency in Hoke and Scotland County. As a matter of fact, if you look at the North Carolina roadmap for me, for the last 4 years, Scotland County has been 98 or 100 out of 100 counties as far as juvenile delinquency and juvenile adjudications. So if that's one of the things that we're supposed to do as a district attorney is to advocate for the community that we serve, then we should start advocating for some programs that are going to help rebuild our community and also help resolve some of this delinquency. And one of the things we have to do as an attorney, if we're a district attorney, is be invested in our community. And that's why when I came back, I picked up the mantle and started back doing what I was doing before I left, which was helping out with teen court to make sure our youth know about some of the programs that we can utilize to try to help reduce juvenile delinquency and stop so much backlog in the court system. So whenever you are thinking about what a district attorney does, a district attorney is a prosecutor, yes, but it's also the person who represents the position of the district that they've been elected to serve. So if the position of our district says that we need some programs to help with juvenile delinquency, then as the district attorney, we are supposed to, and we're bound to trying to make sure we find some of those programs to make sure we meet the needs. If we have other issues that are going on in our community, we need to bring in programs that are going to try to help our community be better, not just prosecute cases. And prosecution is all well and good, but if we try to curb some of the delinquency and curb some of the criminal behavior, then there will be less things that we have to prosecute. So we do need to focus on prosecution, but we also need to advocate for our community as well in the role of district attorney.
Thank you, Mr. Allen. Mr. Allen, you do have the right of first response. Do you have any questions, sir?
I think that my opponent is right about programs, but what I would say to you about that is someone's got to pay for them. And we've tried a number of programs over the years, and some of them work and some of them don't. So it's sort of a buzzword to say we need programs. But you have to make sure you're making good decisions about what programs you use. And I would say to you also that there are special ethical rules that apply to prosecutors. They don't apply to any other lawyers. You have to be aware of conflicts of interest as a prosecutor. And for example, with teen court, it's a worthy program. It's a good program. It's held in the building where my office is located. But it's a deferral program. And so what happens in teen court needs to be confidential. And if a district attorney is present and hears something incriminating that happens in there, and then for whatever reason, that juvenile offender does not successfully complete the deferral program, and that case reverts back into court, then that can be problematic if there's a prosecutor present when that occurs. Our role is a little bit different than that of other lawyers because we're ministers of justice and we have to respect people's rights. And so what you have to do is always safeguard that right of confidentiality on behalf of that juvenile. So we support the program of teen court. It's a great idea. I know plenty of people who participate in it as judges and as leaders for the young people who serve as attorneys, because there are students that work as the prosecutor and there are students that work as the defense attorney. I have observed teen court on one occasion only when the program was first getting started, because They were trying a traffic case, and it was very fascinating to see those young people in that role of attorney. It's great training for them for the future, and they enjoyed it greatly. But we always have to think about protecting the confidentiality of those juvenile offenders, because if they successfully complete the program, they're not prosecuted.
Thank you, Ms. Nichols. Mr. Allen, do you have any response you want to give?
Yes, I do. And just in regards to the cost of things, teen court is paid for through the Juvenile Crime Prevention Council, which means there's no cost to the state. Those are monies that are handed down to us. And there are a lot of other programs that we can go out and seek grants for that would allow us to defer some of our youth. And so, yes, there is that we do have to keep things confidential, but what most people don't understand is that once you go to teen court, that means you've already been to court and you've somewhat admitted guilt, because that's part of one of the requirements to go to teen court. So there will be no breach of confidentiality, because you've already admitted that what you did, you already admitted that you did it. And so now they're just basically giving you a structured sentence for community service and whatnot. So there is no risk of breaching confidentiality, because the person's already admitted in open court that they've committed the crime. So whenever we think about these programs, I don't want us to be deferred or distracted by the fact that you think it's going to be an additional cost to the county, because we can always go out and find grant-funded programs that can pay for a lot of the things that we want to do with our youth as well as other individuals. So there's not a cost attached to a lot of these programs. The programs can work, and if we just utilize them, because like I said, I think we may have gotten 3 referrals over about a 6 or 7 month period. But this is for any child who's 17 to 16 years old. And if my child got in trouble, I'd much rather he have to go through teen court and do some community service and be given a second opportunity than to have to go to regular court and end up on on regular probation if they're 16 or 17. So those are some things that we have to consider. And again, we have to always keep in mind that we are here to advocate for our community and our role as any attorney, especially if we're an elected official. So whenever we get elected in these positions, we have to make sure we do what's in the best interest of the community, not just what we think is in the best interest of the community, but we have to actively research what's going on, find out, and research things and go out and implement things that are going to try to make our communities better. Thank you.
Thank you, Mr. Allen. That is all the time we have for rebuttals. So we'll move on to the next question.
Question number 2, what qualifies you to be the Hoke and Scotland County's district attorney? So what qualifies you to be the Hoke and Scotland County's district attorney?
Mr. Allen, you have first response.
Well, first and foremost, yes, you do need to know how to prosecute a case, but anyone who has gone to law school, as these 2 attorneys can tell you that on the front row, prosecuting a case means just proving that all the elements of that particular case have been met in order for you to be able to get a prosecution. And so that's not something that, yes, you do need to know how to prosecute a case, but if you go to law school and you graduate, then a lot of times you are trained on how to prosecute a case by just proving the elements. And so what qualifies me also is my passion and my desire to come back and serve my community. That qualifies me because not only will I prosecute cases, but I also use discernment in deciding how we're going to prosecute cases, and also be fair and be like our district attorney said, be a minister of justice. But whenever you minister and mete out justice, you have to do it fairly. And I'm not saying it's not being done now, but you have to be able to do it fairly and consider everything that's going on whenever you deal with these cases. So what qualifies me is my passion for Hoke County, my desire to make Hoke County better, and my desire to upgrade our court system. Because even though we have good officials elected right now, we also have programs that we are not using, like dispute resolution, that would reduce some of the backlog in our courts. We have programs that we don't have, like, unless I'm mistaken, pretrial monitoring, which means if a person is a sex offender and they can bond out, I would still want that person to have to report back to the court system. I want them to be on some kind of electronic house arrest or pretrial monitoring. And so those are some of the things that we need to consider whenever we come back and we start determining who's going to be our district attorney. And having worked in various counties and throughout the state as a private practitioner, I've been exposed to some of the things that other court systems have. And I was somewhat taken aback when I came back to Hoke County and asked for things that we don't have that are commonplace in other counties. And so those are some of the things that qualify me. My experience, not only just here, but also I was a juvenile court counselor in Scotland County. I've worked with a lot of programs. I've worked with mental health agencies. I've served as clinical directors. I've done a lot of things throughout my life, and I understand the importance of catering things to the needs of the community. Thank you.
Thank you, Mr. Allen. Ms. Newton.
2 minutes is real short, so I hope you got one of these. I've got 20 years experience doing this job. 2 years as a volunteer, 5 years as an assistant DA, 16 years as your DA. I've been all over the state. I've been to specialized training. I've been all over the nation, specialized training. I know how to be a prosecutor. But I want to address a couple of things that Mr. Allen said. First of all, we tried the pretrial release program from the jail 10 or 12 years ago. It didn't work. You cannot come to the table with ideas like that by yourself. You're not an island as the district attorney. You're a member of a team. The team is the sheriff, it's the chief district court judge, it's the resident superior court judge, it's the clerk of court, it's the chief of police, it's the public defender. We have a criminal justice partnership with those individuals. Every decision we make in this judicial district, we make as a team. I don't make it, we make it as a team. We come together. The jail is the sheriff's, it's not mine. It comes out of his budget. When we tried 10 or 12 years ago to do the pretrial release program, it came out of the sheriff's budget. That means patrol has to be cut, resources have to be cut, something has to be done away with to pay for it. And the problem is, I don't want a sex offender at home with a minor if he's a sex offender. So I don't necessarily think everybody ought to be let out of jail. Some people need to be in jail. We have a bond policy, it's set by our team, public defender, DA, sheriffs, chiefs of police, chief district court judge, resident superior court judge. So I would say I'm against the pretrial release program. We tried it, it failed. As far as the Dispute Resolution Center, that was a Republican plan. It was passed by the Republican legislature a couple of years ago. It was done because there wasn't enough money in the state because of the bad economy to fund the court system. It's a civil program borrowed and given to the criminal court system. Our team met and we looked at it and we decided against it as a team. And I'm going to tell you why. People in this community are poor. And guess who has to pay for that program? The individual has to pay for it. And so if you get to go to dispute resolution, then you got to come up out of your money, out of your pocket with the money to pay for it. And a lot of our people lost their jobs. They couldn't afford to pay for it. So we do it for them free.
Thank you, Ms. Newsom. Mr. Allen, right at the spot.
Yeah, and again, since court cost in Hoke County is $188. Alternative dispute resolution in Cumberland County costs $50. So if I had to choose between paying $188 or $50, I'm going to choose the $50 every time. And I don't think I said anything about we should allow sex offenders to go home. I said if a person is bonded out and they are a high risk to reoffend, then there should be some kind of reporting requirement. And if we're working together, one of the jobs of an attorney is when I go out, my job is to convince the jury of whether or not my client is guilty or not. So if I'm a part of a team, one of the things I should do is convince the team what's in the best interest of my community. And one way we do that is advocate for programs that we believe in and stand fast on those programs and continue to advocate for those programs. So my job would be to try to convince the other members of the team what we need to try. And just because something failed at one point does not mean it should never be tried again. Because there are a lot of programs that have been tried and failed, and then you bring them back to the table, and guess what? They can work the second time around if you have the right people in place to advocate and push for them. So sometimes it's not so much the program failed, sometimes it's the people who were trying to implement the program did not have a passion to make sure those programs went forward. So instead of saying a program failed, ask why did the program fail? And if you can tell me why the program failed, then we can try to fix it if it's a worthy program that would be a good fit for our community, and we can go back and make the changes to the things that didn't work the first time around and make sure the second time around we don't make those same mistakes, and we push those programs and we make them work because it's what our community needs. So if we have programs that our community needs, it shouldn't just be an option to say, it didn't work when we tried it last, so we're never going to try it again. We should see what we can do to make it work so that whenever our people need a program, we can't just say, well, we tried that in 2003, it didn't work in 2003, so now in 2016, now that things have changed, the whole climate of Hoke and Scotland County have changed, we're not going to try it again. No, I believe you keep trying things until you find a fit. If that particular program didn't work, then you find another program that may work. Instead of saying, what, it didn't work before, we're never going to try it again. So, thank you for your time.
Thank you, Mr. Allen. Ms. Newton, your response?
When we do the deferrals, we don't charge people with court cost. Judges can waive and remit the court cost. If we do the dismissal, we don't collect the court cost. Alternative dispute resolution is a mediation program where you refer people to mediation, they pay the mediator, and they work out an agreement. We do that now with the defense bar. You have, if the person has an attorney, and even if they don't, you can mediate and work out an agreement between the parties, and then you can dismiss the case and not tax the cost to the participant. At the time those programs started to be introduced and that legislation came along, It was the same time that a whole lot of factories were closing down in Scotland County. It was the same time that a whole lot of people were losing their job. It was the same time that a whole lot of people were talking about how they were going to pay their taxes or keep the lights on or keep their houses from being foreclosed on. So we, in our court family, decided that we would rather provide the service without a cost to the citizen than we had to implement a program that cost them money. As I said, programs are good ideas. You should listen, and if it's a good program, you should do it. But you shouldn't go back to something you've already tried that didn't work. The reason that it didn't work is because the citizens wanted a Parks and Rec Center in Hoke County more than they wanted to help people get out of jail. And you got to take the money. The commissioners were great. They appropriated the money, they assisted with it, we tried the program, and then as a team, everyone decided that the citizens wanted a better use for that money. And so I'm all for having an open mind to listen for a program, and if it works, that's great, but to waste taxpayer money for a program that doesn't work or that the citizens don't really want, there may be some people who are very focused on getting people out of jail. But the citizens at large would rather have a rec center their kids can play in out there on 211. In Scotland County, they'd rather have a good public school system. There's a big debate down there about the school floor because their local tax rate is so high. I'm out of time, sorry.
Thank you,
2
Ms.
minutes goes fast.
On to the next question.
How do you think we can have quicker trial dates? How do you think we can have quicker trial dates?
It's a problem. I wish it wasn't, but I'll be honest with you about it. I have been doing this job for 20 years, and there have been a lot of changes legislatively over that 20 years. DAs used to have calendaring authority. We don't anymore. I practiced at a time when the DA could set the trial calendar, call cases for trial, and move them along. Then the case management legislation came down, and calendaring authority was taken away from district attorneys legislatively, and now you have to have a written plan in place, and it incorporates other individuals who set the schedule. I constantly ask for more court. Our court is allocated by the Administrative Office of the Courts in Raleigh. You can't have any more than they give you. We have limited facilities. Chairman Leach will tell you that for a number of years, our resident Superior Court judge has been asking for a new courthouse in Hoke County. We basically have 2 courtrooms in Hoke County, one where we can do jury trials, one where we can run district court when jury trials are in session. If you try a big case, it takes weeks. I've been in trial as much as 11 weeks at a time. I'm saying 11 weeks on one case. And so you have to work within the resources you have, and you have to work within the time that Raleigh decides you can have. We're constantly looking at the Superior Court case management plan, constantly trying to move forward of how we can get cases to trial faster. It's always something that needs improvement. It's something we work very hard on. The more facilities we have, the more personnel we have, the faster we can do it. My office regularly opposes continuance requests, but under the plan, a defendant is entitled to a minimum of 3 settings before we can even push the case for trial. And then once we get it on the trial calendar, we have to get the other side on board to try the case. If you go look at the record, you will see that by and large, once that case is on the Superior Court docket, my office is consistently opposing continuance requests because we want to get cases to trial. We did a lot last year. We processed hundreds of defendants, tried multiple jury trials with the resources that we have.
Thank you, Ms. Newton. Mr. Allen.
Well, I think if, in order for us to get quicker trials, we have to make sure we're expeditious in everything we do without missing things, and making sure we have thorough investigations that are being done and that we thoroughly review things. And when things do come before the court, we have to make sure that we have the records together. As a defense attorney, if I have a client who's been in jail for a year, year and a half, and he's not been indicted, then that's going to slow down the process of getting a case to trial. And so those are some of the things that we have to look at. We have to look at having an infrastructure that is going to have some kind of system in place, so a system of checks and balances, so we can know exactly what is going on with each and every individual case. And that is exactly why I said earlier, we need some of these programs so that we can decrease some of the backlog in the court system. And yes, no, and I'm not advocating for letting people out of jail, but if I'm a first-time offender of a minor offense, why let that person sit in jail for 3, 4, 5 months and let that case keep lingering over and over when you can try something like alternative dispute resolution. Try something like, so you don't, because like I said, we have limited resources over here, and if juvenile court has to take a day, and a lot of those cases can be deferred to teen court or some other program, then it will decrease the backlog of having so many cases going before the court. So that is why it is extremely important that we do have some programs that will allow us to mediate certain things that don't require us to have to take them to court, so we can get through some of the more important things a lot faster, because like we were just told, we only have 2 courtrooms in Hoke County right now. And maybe we could try to allocate another place to have a session to. Right now with only 2 courtrooms, why not defer as many things that are not serious offenses? Why not defer some of the non-injury related or cases that don't require any kind of restitution? That's even more reasons why we need to have some deferral programs. That's even more reasons why we need to try to work through some things so we can decrease our backlog in court, so we can get some of these serious offenders through the court system, out of jail, into prison if that's where they belong, or if they're not found guilty, then back out of our jail system.
Thank you, Mr. Allen. Ms. Newton, your response?
I do a lot of deferral programs. I've been running a deferred prosecution program since the day I took office. I'm one of the few DAs in the state that has a written deferred policy. I've actually been asked to present it by the North Carolina Conference of District Attorneys and share it with other DAs because, as I said, I'm one of the few that have it. Since 2005, I've referred about 500 young people out of court, giving them a deferred prosecution, which is basically a second chance. I want to tell you that 72% of them were minorities. I'm very proud of that. I've got a kid right now that's playing in the NFL that got in trouble when he was in Scotland County High School. And I gave him a deferred prosecution, and he's been very successful, and he's done very well. I've helped a lot of kids. I believe in deferrals. I believe in second chances. I've been young, certainly haven't been perfect, made mistakes. People gave me a hand up, gave me a second chance. I think you help young people when you can. But I also believe you drop the hammer when you can. And not too long ago in Scotland County, we sent a man to prison for 107 years for molesting a child. And so I think you have to have both. And I do have both. And you need experience in this job. You need to know what you're doing. You need to have experience with jury trial work. In fact, you can't even qualify for some cases unless you have a certain amount of experience. There are all kinds of parameters about who can do the more serious work. We try to get everything we can out of the court system that's minor, that's insignificant, that we can resolve, that we can work out, that we can give someone a deferred prosecution. And then we try to use those limited resources we have in Superior Court for serious violent offenders. We don't leave people that are charged with minor offenses sitting in jail. We run a program with the Public Defender's Office to pull those people up to court early to get them out. At Christmas time, we run a program where we send people home for Christmas. If there's anybody in jail, we take the jail list, we go through. If you're in jail and you got a minor offense and you're a nonviolent offender, we'll let you go home for the holidays. We do all kinds of things with limited resources to make sure that we make a difference in people's lives in a positive way.
Thank you, Ms. Newton. Mr. Allen. Okay. Moving on to question 4.
As district attorney, will you be able to be impartial? So as district attorney, will you be able to be impartial?
Mr. Allen.
Yes, if elected district attorney, I would be able to be impartial. I've already told all my family and friends, if I get elected, don't expect to get out of jail free card, and I'd hate to have to send you to jail, so you better be on your best behavior. So yes, I do believe I could be impartial if elected as district attorney, because I do have a desire to see our community grow. And you can't say you want our community to grow if you sit back and you only offer special treatment to certain people. So in order to be able to be a district attorney, you do need to mete out justice in an impartial manner. You need to be able to assess every case, not based on anything other than the facts of that case and the parameters of what happened, and then make a fair and just decision. So yes, I do believe I could be impartial, even though I am a resident, lifelong resident, well, minus 8 years, of Hoke County. So yes, I do believe I could be impartial, in fact, in spite of the fact that I look out and see family members, friends, and cousins who I would hate to have to send to jail if we found them guilty of a crime.
Thank you, Mr. Allen. Ms. Newton.
Yes, I could absolutely be impartial. I've done it for a long time. I'm homegrown. Sometimes it's tough You have family members get in trouble. The sheriff's office caught a cousin of mine one time with some drugs, and he showed up at my house, although he had not been there in a very long time, and he wanted some help, and I said, sorry. You have to be able to do that. You have to be able to tell people that you're going to do what's right no matter who it is. And I've done that, and my record speaks to that.
Thank you, Ms. Newton. Mr. Allen, would you like to give a response? Ms. Newton, would you like to give a response? Okay.
And our last question, do you support the death penalty? Why or why not? Do you support the death penalty? Why or why not?
Ms. Newton?
District attorneys don't make the law. We're enforcers of the law. We're soldiers. We follow the law that's passed in Raleigh and Washington. In North Carolina, the death penalty is the law. I will tell you that I put somebody on death row. It's not a moment to celebrate. It's a very solemn, very serious thing. I have prosecuted more than 75 homicide cases, done more than 120 death investigations. A lot of bad things happen to a lot of people in our community, and you have to be very serious and very solemn about it. I will prosecute someone for the death penalty. I have on multiple occasions. I think it's important to know if your district attorney has jury trial experience, because you need jury trial experience. Not everybody who graduates from law school can try a case. I mean, I went to a very good law school, won an award in law school for being the best advocate. But I'm going to tell you what, most people I know who graduate from law school can barely find the courthouse door, much less know what to do when they get in there. Law school is about books. That's why we call it the practice of law. You need practice doing what you need to do. I will tell you this, in every murder case I've had since I've been the elected DA, I have offered every murder defendant the opportunity to take a life sentence. If they take a life sentence, I pull the death penalty off the table. If they don't, then I will do my duty. Because in North Carolina right now, it is the duty of the district attorney to seek the death penalty in appropriate cases. They are limited, they are few, but in the ones where it's your duty, you have to take an oath that you're going to do it. And if you can't, then you shouldn't be the district attorney. Not at least as long as the death penalty is the law.
Thank you, Ms. Newton. Mr. Allen?
And as our district attorney so eloquently stated, regardless of what your personal opinions are, you do have to uphold the law of the land. And right now the law of the land is that we do have the death penalty here in North Carolina. So if a person came up and the circumstances required it, then we would have to consider the death penalty. And we'd also have to look at every aspect of everything that goes on. I was asked, if these things happen, would you be willing to go after seek the death penalty? And I told the person I couldn't answer that question because you can't ask a question about a death penalty in the vacuum. So every case is looked at individually, and you have to look at everything that happens with that case. Because if you have a person who's schizophrenic and they're having a schizophrenic break and they commit murder, should you seek the death penalty in that case? If a person is incapacitated by no will of their own, should you seek the death penalty in that case? So certain times you're going to seek the death penalty, and certain times you will not. But as long as it's the law of the land, we're bound to uphold every law of the land. So yes, I would have to say that I would uphold the law of the land. And sometimes, regardless, you have to remove personal opinions and personal feelings from things. So as long as the death penalty is an option, if the case warranted it and all the facts lined up, then yes, we would have to seek the death penalty in some cases. And even though that would be a very, very hard thing to do, you have to do what's in the best interest of your community. You have to do what's in the best interest of your district if you're elected as the district attorney.
Thank you, Mr. Allen. Ms. Newton, would you like to give a response?
Sure, because 2 minutes is so short. Along those lines, I just want to say to you that there is a lot of law on the death penalty. It is not something that, as I said, every case qualifies for. It is a very, very specialized skill. There are few prosecutors in the state of North Carolina that are experts in capital case work. There are very, very few defense lawyers who are. In fact, in order to even try a capital case, there's a whole list of qualifications that you must have. You have to have a minimum number of jury trials tried to verdict in order to even appear and be responsible for a capital case. So it's not like you just sit down in a vacuum and you make a decision about the death penalty. You have specific statutes on point. You have North Carolina and U.S. Supreme Court decisions on point. You have special ethical rules. You have IDS requirements, that's Indigent Defense Service requirements, about skill level and competence. There's specialized training in order to do capital case work. As I said, I've prosecuted more than 75 murder cases. I've done post-conviction work in capital cases. I've worked with the North Carolina Attorney General's office because all those cases are automatically appealed. I don't know if you know that or not, but a life or death sentence is an automatic appeal. So I've worked with the Attorney General's office doing the appellate work in those cases. It's a very, very specialized skill, and there aren't a lot of practicing lawyers that actually even meet the requirements anymore to get on the list in order to be able to do those cases. So I would tell you that I also have a written policy on the death penalty in my office. Don't think a lot of DAs do. I have an entire list of factors in addition to what the law requires before we even make the decision to seek the death penalty. I meet with every family of a homicide victim to talk to them extensively about the law and about what we should do, what we shouldn't do, and always take that decision very, very seriously.
Thank you, Mr. Allen.
We'll now hear 2-minute closing remarks. It's your opportunity to touch on anything that you choose and to leave a lasting impression on the audience.
Mr. Allen.
And again, we thank everyone for coming out tonight, and I appreciate you all taking the time to hear what we had to say. And I wanted to let you all know that regardless of who you elect for our district attorney, of all our elected officials, we're going to have to demand more. Demand that we do what our elected officials do, what's in the best interest of not ourselves, but in the best interest of Hoke County. And in the best interest of Hoke County right now, and Scotland, since we're one judicial district, we need to start looking at things that are going to make our district better. We need to make sure that we incorporate things into, no matter what we do in the court system, that's going to make sure that every person who comes through our court system is treated fairly, to make sure that every person who comes through our court system has the same option as people in larger cities if we can afford to get those programs in place. And if we can't afford them, then we need to start seeking some grant money. So regardless of whether, I'm hoping you vote for me, but regardless of who you vote for between March 3rd and the 15th, make sure whoever you vote for, that you demand from them that they give you the very best and quality of service that you desire. Make sure you demand from them that they advocate for your, not only for prosecuting cases, but also they advocate for our community. So whenever you elect these officials in whatever capacity, that's your obligation as a citizen who votes and pays your taxes to make sure that you demand more. And if you elect me, I promise you I will give you everything I have to make sure that I am not only just a prosecutor, but also an advocate for every citizen in Hoke and Scotland County. Thank you.
Thank you, Mr. Allen. Ms. Newton.
2 minutes is really quick, so this is what I'm going to say to you. For the last 6 or so years, the legislature's been trying to wipe us out and get rid of us. They want big city in Hoke County and Scotland County. They actually want to eliminate this position. For the last several years, I've been going to Raleigh with a number of other rural district attorneys arguing to keep the rural districts in place, because the legislature wants mega districts. They want the district attorney to be unapproachable. They want big money, big city money, and big programs. I don't. You know what I like? I was in Walmart shopping for groceries with my 2 daughters, and a murder victim's daughter was on the line coming down as I was. And she saw me, and she came over and cried on my shoulder in Walmart for 30 minutes. She knew who I was the minute she saw me. She knew me personally. She'd met with me. She knew I cared about her. She knew I cared about her family. And I stood in Walmart, and she cried on my shoulder. That's what I like about small town. I don't care about big city programs. I care about people. I care about doing what's right. I care about the job of the district attorney. It's not our job to always do what the citizens want. It's our job to make the tough calls and do what's right. That's the only thing that matters when you're the DA, is do you do what's right? Do you treat people fairly? I will tell you, you look at my record. I've always treated people with respect. I've always treated people fairly. I've been tough, but I've been approachable and I've been fair. My daughter, who's here tonight, asks me all the time, "Mama, how do you know that person?" And I say, "Baby, his house was broken into, or his son got a speeding ticket, or his son got arrested on a drug charge." People can approach me wherever they see me, the car wash, the grocery store, a restaurant, and I'm going to talk to them, and I'm going to do the best I can to help them, because I believe in public service. That's why I've been doing it for more than 20 years. I want your vote on March 15th. I hope you'll give it to me. I hope you'll give it to me because I'm the best person for the job. And no offense to my opponent, but I'm the one who knows how to do it.
Thank you, Ms. Nichols.
I'd like to thank each and every one of the candidates. I would like the candidates for commissioner race to stand wherever you are at this time. Mr. Austin, Mr. Bobby Wright, Mr. James Leach, and Mr. Fowler. These are your candidates. These are your candidates for your district attorney office. Remember, early voting starts March 3rd through the 12th, and primary is on the 15th. So please come out and cast your vote. I hope they sent something tonight if you were wavering and didn't know who you wanted to vote for, that you got your answers. If not, I'm sure they would not mind you approaching them and asking them if there is something that you're still not quite sure who you should give your vote to, that they would be willing